Welcome to the 2020 Constitution Day celebration of Tulane University and Tulane Law School. My name is Sally Richardson. I'm the Vice Dean for Tulane Law School, and we're so excited to have you with us tonight. The birth of Constitution Day dates back to the signing of the U.S. Constitution on September 17, 1787. In 1952, the U.S. Congress passed legislation commemorating the forming and signing of the Constitution on September 17th. And in 2004, Constitution Day became more than a day of commemoration, but also a day of education at the behest of the late Senator Robert Byrd. Having met Senator Byrd many times when I worked on Capitol Hill, I can attest that Senator Byrd always kept a pocket copy of the Constitution like this in his jacket pocket and discussed the founding document with everyone, from constituents visiting his office to his colleagues on the Senate floor, and even with eager young staffers like myself who happened to catch his ear. This year's topic for our Constitution Day is race, racism, anti-racism, and the Constitution, a look at the past, present, and future. There is no better time to be discussing race and the Constitution than now, as our country wrestles with and protests over the murders of George Floyd, Breonna Taylor, and so many other Black lives. There is no more important time than now to discuss these issues. Tonight, I am delighted to present to you an amazing panel of legal scholars with expertise in the Constitution, race relations, and social justice. To introduce our panelists tonight, we have an amazing team of students who have been working hard with the Tulane Anti-Racism Task Force. Tonight, as our introducers, we have Michelle Domingue, the BALSA Vice President, Jade Anglade, the head coach for mock trial, and BALSA Moot Court Chair, and Tommy Barnett, our SBA President. And so with no further ado, let me turn over to Tommy to introduce our first speaker for the night.
Thank you, Dean Richardson. We are so excited to have our first speaker, Professor Robert Wesley. Professor Wesley is the Lochev Professor of Legal Ethics and Professional Responsibility at Tulane Law School and a leading international expert on the issue of reparations, having authored more than a dozen law review articles on the subject. Professor Wesley is currently working on a book, Extraordinary Means, Ordinary Justice, Reparations Through the Lens of Wrongful Enslavement, to be published by Cambridge University Press. Thank you for joining us tonight, Professor Wesley.
I'm very honored to participate in this. Excuse me, am I muted? I'm very honored to participate in this event to both examine the aspects of the Constitution, focusing first on the Constitution's past, and then later on what we hoped the Constitution's future will be. Personally, I find it quite daunting to review this history of the Constitution, given the current attacks that have been made on the Constitution in this very divided political environment in which we find ourselves at the moment. But nevertheless, I thought I would start my presentation by offering a quote from the late, great James Baldwin. Not everything that is faced can be changed, but nothing can be changed until it is faced. So with that invocation, I want to first see if I'm able to access my PowerPoint, and I'll begin to review the Constitution's past. So one thing that we know is that the word slavery was omitted from the original Constitution. However, it was referenced, and it was referenced first of all in Article 1, Section 2, Clause 3, which related to representation in the House. This is the so-called 3/5 clause. And it was one of the compromises that was offered by the Northern delegates at the Constitutional Convention to induce the Southern delegates to the Constitutional Convention to accept the Constitution. So under this provision, Black Americans were counted, enslaved Black Americans were counted as 3/5 of a person for purposes of determining representation of the states in the House of Representatives, and it also impacted the number of delegates to the Electoral College that the states would be allowed to have. There's also Article 1, Section 9, Clause 1, which prohibited Congress from outlawing the importation of enslaved persons until 1808. And finally, there was Article 4, Section 2 of Clause 3, which required states to deliver up any person held to service or labor who had escaped into its territory. So these are known as the slavery compromises. And it just so happens that coincident with preparing for this event, I was teaching my critical race theory seminar and discussing with my students the work of one of the deans of critical race theory, Derek Bell. Professor Bell developed the concept of the principle of involuntary sacrifice. And involuntary sacrifice is described by Bell as a principle, but it's not a moral principle. It's a principle of how to analyze race relations in American history, and with particular reference to the Constitution, but also more broadly. And the idea here is that Black rights have often served as something which was involuntarily sacrificed when there was a dispute between white Americans about what policy should be in this country. So one of the founding fathers, James Madison, was a slave-owning Virginian, often considered to be the father of the Constitution. And he, along with other Southern delegates, fashioned a series of compromises, these slavery compromises in the Constitution, that were aimed at preventing friction over slavery among the states by leaving the institution largely unregulated. These compromises in the Constitution led a leading abolitionist, William Lloyd Garrison, to describe the Constitution as an agreement with death and a covenant with hell. The slavery compromises enacted by the Constitution led to additional legislative compromises with pro-slavery interests. So, for instance, there was the Fugitive Slave Act of 1793, which, among other things, denied jury trial and due process to escaped slaves. There was also the Missouri Compromise of 1820, which instituted a ban on slavery in the Louisiana Territory, except for the state of Missouri. Keep in mind that at this time, there were 11 northern states that were opposed to slavery and 11 southern states that favored slavery. And the admission of Missouri to the Union as a state would have disrupted the balance of power between the two sectional interests. And so, as part of that compromise, the state of Maine was added as a free state. Missouri was added as a slave state. And the 3630 latitude or parallel was established such that any additional states added in the future would, if they were slave states, they would have to be below that parallel. If they were to be free states, they would be above that parallel. And this was, again, yet another compromise worked out by white interests in order to maintain a balance of power between them. There was not only the Missouri Compromise, there was also a second Missouri Compromise in 1821. And under this compromise, free Negroes and mulattoes were excluded from residence in the state of Missouri. So again, Black rights compromised in order to settle policy difference among white Americans. There's also the gag rule, the House gag rule that was instituted from 1831 to 1844 that prohibited discussion of abolitionist petitions in Congress. This was, again, in order to appease pro-slavery interests. And then there was the Compromise of 1850, which allocated territory seized from Mexico as slave or free, among other provisions. There was the Kansas-Nebraska Act of 1854, where slavery was to be determined on the basis of popular sovereignty, as they would say at that time, or just really by popular vote. And finally, on the eve of the Civil War, there was the so-called Crittenden Compromise. This was an unsuccessful proposal by the senator from Kentucky, Senator Crittenden, to guarantee the permanent existence of slavery under the Constitution in the slave states along the boundaries established in the Missouri Compromise. The Crittenden proposal, however, was unsuccessful in preventing the start of war between the states. One additional factor that led to civil war was, of course, the Dred Scott decision. A husband and wife filed a lawsuit in St. Louis, Missouri, in circuit court in 1846, seeking their freedom, setting off an 11-year odyssey that would lead eventually to civil war and culminated in the most famous and offensive decision of the Supreme Court. Dred Scott was held as a slave by a family in Alabama that moved with him to Missouri. He was then sold to a man named John Emerson, who took Scott first to Illinois and then to Wisconsin, and also to Fort Snelling in federal territory that would eventually become the state of Minnesota. There he met and married Harriet Robinson, who had been enslaved by an Indian nation. When Emerson took them and their children back to Missouri, they filed their claim for freedom. They sued under a state doctrine referred to as once free, always free. This doctrine is actually derived from a case that was decided in England before the Revolutionary War called Somerset versus Stuart. As an enslaved person held in a free territory, your freedom was established as a matter of law and remained enforceable even if you return to a slave state like Missouri.
I hate to interrupt Professor Wesley, but it's time to move to the next speaker.
Well, there are additional compromises that I would have loved to share with everyone, but I'm out of time, so I will stop.
Thank you so much, Professor Wesley. We look forward to hearing you again at the end of the presentation today.
Okay.
Our next speaker is Professor Steve Griffin. Professor Griffin is the W.R. Irby Chair and the Rutledge C. Clement Jr. Professor in Constitutional Law at Tulane Law School. Professor Griffin is a prolific writer on constitutional law, having written 3 books on the subject. In his most recent book, Broken Trust, Dysfunctional Government and Constitutional Reform, Professor Griffin explores the current lack of trust in our American government, how our constitutional structure led to the breakdown in trust, and how we can find a path forward. Currently, Professor Griffin is working on scholarship focused
I couldn't hear.
That is your cue to start. Currently, I think Jade dropped out for a moment, but currently Professor Griffin is working on scholarship focused on the history and use of race in the 13th, 14th, and 15th Amendments. And so with no further ado, Professor Griffin.
Okay, thank you very much, Jade and Sally, and I hope you all can hear me. I'm indeed speaking to you about the Reconstruction Amendments, and I'm doing so from the perspective of a project that I've pursued for about 2 years, which has resulted in an article called Optimistic Originalism in the Reconstruction Amendments. I'm speaking to you on the basis of that article and about 2 years of research I did into roughly the recent historiography of Reconstruction. And I'm going to try to provide what I found to you in a concentrated dose, so to speak. I'm not going to try to cover everything, and I'm certainly not aiming my talk today at the legal theory called originalism. I'm really speaking to the substantive knowledge I acquired about the Reconstruction Amendments by doing this project. I'm trying to concentrate especially on things that I either didn't know or wasn't fully aware of when I began my research. But there is something about the title and a tribute I want to give before I launch into it. I titled my article Optimistic Originalism because there are a lot of people, legal academics, who count themselves originalists, but are nonetheless very optimistic. That is, they're very favorable toward the idea that the Reconstruction Amendments do provide foundations for all of the doctrinal developments that we're familiar with. And so these originalists do not reject the effort against segregation. They don't reject Brown versus Board of Education, as is often claimed that originalists do. They believe that the amendments properly read do support them. But in a larger sense, there's a larger group of people who are also optimistic. Many people who do not count themselves as originalists and would count themselves more on the liberal side of the spectrum are also quite optimistic about the Reconstruction Amendments, and there's plenty of evidence on their side. Just recently, I don't have a share screen, but I will point out that one of the most helpful books written just recently about all of the amendments was a book by Eric Foner called The Second Founding. And in titling his book, The Second Founding, Professor Foner, certainly one of our leading historians on the period, is reflecting a point of view that has very strong support over the years, which is that the Civil War and Reconstruction, the whole process, really constituted was a self-conscious way to rethink the whole American experiment. And in a certain sense, these people think that everything going forward must be reconsidered in that light. Indeed, the whole original Constitution has to be rethought, in a sense, in light of the Reconstruction Amendments. I want to pay tribute to that, but to also a sense of skepticism I picked up in my own education, just to pay tribute to a couple of people who really influenced me. There was a very kind of unusual for the time African-American law professor in the 1970s, Marilyn Yarborough, who eventually became the first African-American dean at Tennessee. She put me through a seminar with Derek Bell's famous case book that Robert might have mentioned, a case book that I think changed a lot of people's perspective on race in American law. That's basically what it was called. What I picked up from Bell was not so much skepticism toward the Reconstruction Amendments, but a sense that they required perhaps a more fundamental rethinking of especially Americans' relationship to government than was anticipated at the time or was thought through at the time they were adopted. And so that's part of my inspiration for my current project. One thing, though, that unites people like historians like Professor Foner and historians that have been a little more skeptical of what the reconstructors or the people who wrote these amendments really intended or designed. But one of the things that unites them is a question that still bothers people today. I can tell this. People are still asking this question over and over again. They're asking the question, given that these amendments were obviously somewhat earth-shattering compared to what was gone before, given that they were efforts to try to break a chain that Robert was describing, a chain of compromises. Why is it that Reconstruction failed? Now, perhaps there are some better or worse ways to ask that question, but I assure you, many people today are still very puzzled about the sequence of events that could have, and there's much discussion of the betrayal of Reconstruction. I want to do the best job that I can, therefore, in laying out not only some basics of the Reconstruction Amendments, but I want to try to give you my best answer as to why progress toward racial justice, racial equality, however you want to put it, but I'll say racial justice, why progress was in effect frustrated. Was it perhaps something built into the Reconstructors' project, something perhaps not immediately evident on the basis of the amendments themselves? Well, here, in order to do this, perhaps approach the amendments from a somewhat different context, or just suggest a different sort of prism in which to view them. So I'm not going to really start right at the beginning or take you through all of the text. I'm going to point out some common features the amendments had, and then some common assumptions, and we'll go from there. One common feature all of the amendments had, 13th, 14th, 15th Amendments, a feature that was not shared by any prior amendment, was that they all gave Congress new enforcement powers. You might be familiar with the claim that the American government is a government of enumerated powers, limited powers. There's actually a dispute about that, but no one disputes that whatever the list is, you have three really important additions to the list. And that's a clue it's also a clue about how the Reconstructors, the people writing these things in Congress, saw themselves and saw their project. They saw themselves in Congress, and Congress as an institution in the forefront of the effort to realize the promise in the Reconstruction Amendments. This was certainly accentuated by a conflict that in many respects produced a constitutional crisis between President Andrew Johnson and Congress. There's a lot to be said there, but it was concentrated into a relatively brief period. And what the period taught Congress was that they would have to do things on their own. And indeed, in the history books, you can read presidential Reconstruction was replaced by congressional or even military Reconstruction. But the important point is that the Congress thought that it would be not only be able to initiate Reconstruction, but could complete the process of enforcement and reinforcing the amendments by itself. And at the lead of that effort there could no other person or institution but the Republican Party. So it's an effort, therefore, led by a party, but also, we could say, an effort that has the limitations that a political party might have. Among other things, that a big chunk of the Republican Party had to stand for re-election every 2 years, and there was no way around this. Republicans were deeply influenced, first by their tremendous success against Johnson in the 1866 elections, for example, and then a later series of elections which caused them to rethink, especially the devastating elections of 1874. That successful election and that not so successful election kind of mark both the beginning and the end of what you might regard as Reconstruction. But the important point is, a political party, okay, not an administrative agency, not the courts, a political party seized control of the Congress, and they were going to be in charge of enforcement. Well, they were arguably laboring, though, under some limits. Some Republicans agreed strongly with the radical promise of the Reconstruction Amendments. Others adhered to more traditional ideas, wanted to see some of what was true before the Civil War last through the Reconstruction period. In my article, I talk about 4 limits. I'm just going to mention them now, but this is by way of just suggesting the ideological limits that the Reconstructors were laboring under. Some wanted to retain traditional understandings of federalism, the understanding of persons that would be dependent, the distinction between civil, political, and social rights, and the idea that government was one of limited powers. This all suggested that the relationship of Americans to government would have to be rethought before Reconstruction would be a success. And I also suggest that's what the civil rights movement of the second Reconstruction really turned out to be about. I can see I'm a little perhaps short on time, so I'd like to just end with the thought that it's interesting, I think, that the 2 parts of the Reconstruction Amendments that had the greatest success were also the parts that were easiest for ordinary people to understand. Namely, the command of the 13th Amendment, no slavery. So as far as I can tell from the history books, chattel slavery died, which we can all be thankful for, and birthright citizenship. Whatever you think about birthright citizenship, and some people still want to re-argue it, I guess want to re-argue Dred Scott, this proved to be easily understood and easy to administer, and it also meant something that everyone at the time understood, which is that the former slaves, the freed people, as historians now call them, were all equally citizens of the United States. Am I a little short on time?
Unfortunately, Professor Griffin.
Sorry?
Unfortunately, yes.
Yeah, so I would just end with that point, because I know people do tend to stress the Equal Protection Clause and so on, but it is striking that the clauses that were least controversial had arguably the greatest legal impact, with the promise of the clauses like equal protection, well, that lay in the future.
Thank you so much, Professor Griffin. And next up, we have Professor Angela Allen Bell of the Southern University Law Center. Professor Bell holds the B.K. Agnihotri Endowed Professorship and serves as director of the Louis A. Berry Institute for Civil Rights and Justice at Southern University Law Center. She is a respected local, national, and international legal scholar and expert on civil and human rights, social and restorative justice, and the interplay between race and justice. It was her research that catapulted the recent movement that in November 2018 successfully ended the use of non-unanimous juries in Louisiana. She is also one of the founding members of the advocacy team that led this effort to reform Louisiana's jury system through the adoption of legislation that would require unanimous juries in criminal trial courts in Louisiana state courts. She has the distinction of having worked on several other historical advocacy campaigns, such as the Angola 3 case, the cases of the Soledad brother John Clutchette, and the case of Robert Holbrook. Thank you for joining us tonight, Professor Bell.
And thank you for having me. I am going to talk a little bit about a book chapter that I am working on concerning the 13th Amendment and the way it intersects with race and justice. And most of the time when there is an attempt to have a discussion about the 13th Amendment and the intersection of race and justice, the conversation is quite predictable. People will often indict the exceptions clause in the 13th Amendment, and they will say that it is in fact the source of all systemic racism. They will cite the 13th Amendment's exceptions clause as the cause of the carceral state. Well, I certainly do not dispute that that exceptions clause is repugnant. I certainly do not dispute that it undermines many of the constitutional protections. But I do feel that these concerns are overstated, and I'd like to talk to you about why. So when we look at the exceptions clause in the 13th Amendment, it appears in Section 1. And Section 1 essentially says slavery is abolished, but in the exception of when a person is being punished for a crime, in that instance, we actually allow the continuation of slavery. You will also find similar language in Louisiana State Constitution appearing at Article 1, Section 3, making a reference after it promises Louisiana citizens individual dignity. That protection ends by saying we in Louisiana also endorse the idea of holding people in slavery if in fact they are convicted. So for those who espouse the belief that our problem involves the exceptions clause, I would like to propose that we just remove it momentarily. So now if we take that language out of Section 1, we will see something along the lines of there's no longer slavery or involuntary servitude. My question is exactly what will that accomplish? In other words, what I want to know, is it going to end the disproportionate stops, arrests, prosecutions, convictions, capital sentences, assessments and fines affecting African Americans and minorities disproportionately? Is it going to bring an end to the alarming rate of prosecutorial misconduct? Is it going to stop over sentencing? Will it end the use of Jim Crow juries? And will we suddenly see a ceasing of bias and racism when it comes to laws and policies? So my point is to you, if we take those words out, the carceral state would remain intact. Nothing is going to be accomplished in terms of justice when we talk about simply removing the exceptions clause. Now, I want to make sure that we understand this is a constitutional question. So what I'm really talking to you about when I talk to you about the carceral state and slavery continuing is liberty. It is justice. These are constitutional promises that I am talking to you about. I am talking to you about at a moment in time where this document tells me that I have these promises. There are 2.3 million people incarcerated. There are another 4.4 million people under some form of penal supervision. So now I would like to ask us to juxtapose for just a second that number that I cited with the fact that there were about 3.5 to 4 million enslaved people emancipated. So now when we hear this, we are now faced with a challenge. How do we reconcile these horrific numbers, the tremendous weight of this, with this precious occasion? Because we are in fact here to commemorate a document that means so much to us as a country. So my proposal for us tonight is certainly we celebrate the genius of the Constitution, but we must simultaneously recognize its infirmities. We must also decide tonight has to be honest. And so as we do this honestly, we realize that this document that we commemorate promises liberty, promises freedom, justice, personal autonomy, the pursuit of happiness, equal protection. We realize at this moment that we really have been walking on a treadmill since 1865. That in fact is the year that we adopted the 13th Amendment. We realize since 1787, the year of the Constitution that allowed slavery to continue to exist. And we realize since 1619, that is the year that mass incarceration started. So let us not ever forget that that system of enslaving people was laying the groundwork for what we now know to be the system of carceral state. That in fact was our first mass incarceration system. So we are confronting tonight the fact that in Section 1 of the 13th Amendment, there is some legislative deception. But we must be mindful of the location, because alongside Section 1, there is something called Section 2, which contains an enforcement clause. And that enforcement clause was offered to us by Representative James F. Wilson of Iowa. And he says, design this language that now reads in Section 2, Congress shall have the power to enforce this article by appropriate legislation. Please don't overlook the use of the word shall. That is not an accident. So when we talk about these drafters who envisioned a Section 2, we really need to scrutinize who these people were in order to appreciate the essence of this gift we were given in Section 2. So we have Representative Stevens, who walked onto the floor of the Reconstruction Congress after passage of the 13th Amendment, and he uttered these words, and I quote, "We find those states now reducing these men to slavery all over again, and declaring that every little petty offense the Black man commits, he shall be sold into bondage." So that even that constitutional provision that we made, it is being avoided and got around by these cunning rebels. Then Henry Wilson goes onto the floor of the Congressional Congress and says during Reconstruction, the poor freemen who a few months ago were leaping and laughing with the joy of a newfound liberty, they are now trembling with apprehension. They are everywhere subject to indignity, insult, outrage, and murder. Thousands, tens of thousands of these harmless Black men have been wronged. They have been outraged by violence, and hundreds upon hundreds murdered. The local authorities screen these murderers. The people protest against punishing the white men for murdering these Black men, and the murderers go unpunished. So these were not naive men. They were not just talkers, these men who gave us the enforcement clause in Section 2. They did many meaningful things beyond draft the 13th Amendment. They gave us the Civil Rights Act immediately after because of these things that they realized were taking form. They gave us the Judiciary Act of 1867 and then swiftly gave us the 14th Amendment. And so I want to be sure we understand their intentions were clear when they gave us this enforcement clause. They did not just want to release people from ownership. They were not just confronting mass incarceration. They wanted to remove the incapacity of slavery. They wanted to eradicate every badge and every incident of slavery. They wanted universal liberty, that as a matter of national, not just local concern. And they wanted to end all, and I emphasize the word all, forms of arbitrary domination. So Section 1 of the 13th Amendment, we have to enforce that by judicial review. That is not the case with Section 2. Congress has the power under Section 2 to address many of the ills that we are seeing people protest every night on the news. And they have acted over the years to do so. They have done things like addressing peonage in 1867. They have banned private housing discrimination. They have enacted a hate crime act under Section 2 of the 13th Amendment. Congress can and should do more. This was not an ornamental part of the 13th Amendment. It was a tactical response. So now as I close, I just keep hearing the voice of Dr. Martin Luther King. Every time I see these protests going on in this country. And what he says when he talks about riots and protests is that we should not confuse what they are. They are merely the language of the unheard. So in 2020, we have people who feel words written 233 years ago have yielded hollow promises. We have people who feel unheard. We have people who feel in 1787, when this document was created in a neutral way to tolerate, to bless slavery, racism, colonialism, and the loss of liberty. They recognize it is doing the very same thing in 2020. So as I close, I do want to say I thought about the hour, and I realized it's late, and I tried to think of a dramatic ending, and I considered perhaps making a really mad, menacing face to show you the repulsion I feel when I see that exceptions clause. And then I thought about doing a great big Botox smile because I'm so excited about the promises that I see in the enforcement clause. I even thought about reenacting a scene from 1854 in Massachusetts at the anti-slavery rally on July 4th, where we had Sojourner Truth and David Thoreau and Lord Garrison, who actually burns the Constitution and the Fugitive Slave Act, and as he does so, angrily calls it a covenant with death and an agreement with hell. But I settled on a different ending because it occurred to me that the Confederates had also written their own Constitution. And I found myself quite troubled to imagine being governed by that document over this one. And so as I end, I choose to credit the framers of the 13th Amendment for the foresight that they had in giving us Section 2, for doing what history allowed them to do. And I end by asking, have you done what history has allowed you to do? And that concludes my contribution to tonight's panel.
Thank you, Professor. Professor Ray Diamond holds the position of the Jules F. and Francis L. Landry Distinguished Professor of Law and the James Carville Alumni Professor of Law at LSU's Paul M. Hebert Law Center. And we are excited to have Professor Diamond as our next speaker. Professor Diamond is a leading expert on the issues of race relations, constitutional law, and legal history. He is the author of the book Brown v. Board of Education, Caste, Culture, and the Constitution, which won the David J. Langham Sr. Prize for Historical Literature. Professor Diamond's work on racial justice is far from just historical, though. Professor Diamond puts his scholarship into modern practice. By way of example, Professor Diamond was recently named to the Governor's Police, Training, Screening, and De-Escalation Task Force. We're looking forward to hearing from you tonight, Professor Diamond.
Well, thank you. And first, I want to say how delighted I am to be back at Tulane, even virtually. I spent 19 and a half years at Tulane, and so in many ways, it is home. So Dean Richardson, thank you for inviting me to be a member of this panel and for bringing me back home. I've been asked to examine current issues of race and the Constitution with a look at the current protest and need for criminal justice reform. In many ways, one would guess that having been recently named to the Louisiana Task Force on Police Training, Screening, and De-Escalation, one might guess that I'm the ideal candidate for such a task. And yet, with the task force in operation for a month, I find myself more than ever in learning mode, so perhaps I am not. There is a virtual forest of weeds out there, and as to how to identify them, whether to pull them or how best to pull them, I have questions of my own. So let me speak not for the task force, nor, by the way, for LSU, and speak broadly not about conclusions I have reached, but about questions that I have. And by way of explanation of what you were about to hear, my current work has me doing what I call a family memoir, in which I try to meld the experiences of my family with constitutional developments to show how constitutional developments, in fact, have results for people on the ground. So with that said, let me say that there is no question that we have a problem, especially in the Black community, with police discretion and with police brutality. The problem and how to deal with it is drilled into the heads of Black children as though it were as vital to their existence as their mother's milk. Stand erect, I was taught when speaking to the police. Be polite, be respectful, not yes, but yes, officer. Not no, no, officer. This lesson did me little good when at 6, I was running to the corner store 2 blocks away to get a loaf of bread for my mother and was stopped by the police. They questioned me. I followed my lessons and still was put in the back of a patrol car and ridden around for 10 minutes until we met with another patrol car that had white teenagers in the back. You see, there had been a fight between Black teenagers and white teenagers, and the white teenagers were kind enough to recognize the truth that a 16-year-old Black kid wasn't a Black teenager. This truth that the cops who arrested me could not recognize, and I was allowed to run home. I'm not sure my parents' lessons in politesse with the police helped 13 years later either, when a police officer stopped me one evening when I was walking in a coat and tie, believe it or not, in a white neighborhood in New Orleans, on my way to the Robert E. Lee Theater. And by the way, you have dated yourself if you can remember that theater as having the best screen in town at one point. I was accosted by a police officer and accused of being a drug dealer. Now, this was before the 9 o'clock show. It was dark. And because oak tree canopies in New Orleans leave broken sidewalks pitch black, I was walking in the street where the light was. When asked, I gave my name, address, and my intention to go to the movie theater where my date was waiting for me. And then I had the nerve to express my doubts as to the police officer's belief that I was a drug dealer, for I believed that he was hassling me because I was Black, and I wanted his badge number because I intended to file a complaint. He refused, and here is where the story about police discretion becomes a story about threatened brutality, because he told me to come where he was, on the sidewalk, in the dark, so he could talk to me. I refused loudly and said that I would talk to him from where I was, in the street, in the light, where people on their porches could see me, and that it didn't matter that he wouldn't give me his badge number because I could see his car's ID number, and records would show who was assigned to it. And so here is where my story is perhaps a story of police training. This police officer, as angry as he seemed to be, and as threatened as he seemed to be by my citation of his responsibility to give me his badge number, this police officer actually gave that number to me and let me go. And while I made it to my movie on time, triumphant in my defiance of arbitrary power, I knew deep in my heart that I had escaped something horrible. And that something horrible was police brutality. I had never seen it, but I knew of it. It was a standard feature of blaxploitation movies that were so popular in those days. News footage of the dangers that police officers represented had been made explicit on the 5:30 news in the early 60s, when we would see film of civil rights demonstrators. My college classmates from places like Chicago and LA told me what they had experienced. And my dad had told me a story of his early days in New Orleans when he had seen a police officer bash open the head of a Black man on a steel edge of a corner sidewalk. Part of my exhilaration at forcing the police officer to let me go was in having forced him to treat me equal to a white kid on the way to the theater. But part of it was the thrill of having escaped a real and present threat, police brutality. We don't have to depend on our parents or our friends' stories or the movies these days to know police brutality. There are universally available recording devices. They are ubiquitous, our phones. And what they record, along with the devices that many police departments force their police to use, confronts us on the TV news, in our social media, and I'm not advertising here, it's just an example, YouTube. Police brutality distances Black people from the very people who are supposedly their protectors, the police. Hostile contacts like the ones in the news, I can scarcely bear to say the names of the victims, or more routine arrests and questionings that involve compliance techniques or verbal abuse, create a fear of the police on the part of many Black folk, a fear that at its very best creates a reluctance to call on the police for assistance or cooperate with police officials to catch the actual bad guys. Police brutality also helps to create a sympathy for criminals on the part of an uncomfortably large number of Black people, or in encounters between the police and those accused of police misconduct. It is often hard to distinguish the heroes from the villains. So this isn't a conclusion, just some questions. That police officer seemed to be afraid of my threat to file a complaint about behavior that was taking place in front of witnesses. Should we have civilian ride-alongs as a standard practice? Citizen volunteers to witness police activity? Should we review the set of protections for police that today is the standard in the form of the Police Officer's Bill of Rights that shields from the record, from public record, and even from police departments past misconduct? Should we make it easier for victims to sue police when they violate our rights? No conclusions, just some questions. Another matter of importance is the failure of police to protect Black people from crime. This is an historic failure. Recent studies have increased our count of the number of Black people who were lynched in the age of lynching that ended only in 1969. Over 5,000 people. And the histories of those times reveal that often police officers either actively participated in these lynchings or, more likely, failed to do anything to stop the mobs that did their awful deeds. In my family, we have a distant cousin, Freddie Moore, who was lynched in Labadeville, Louisiana in 1937, dragged behind a car hung from a bridge across Highway LA1. There was once a time that my dad brought the family to that spot. It was November 1st, All Saints Day. Usually we would go to Thibodeau to tend to grave sites, family grave sites there, but this time we also went to Labadeville. And on that spot, I prayed for Freddie Moore and thought on the lesson that Dad, that in a dangerous world where white people were fighting to save the Southern way of life, police could not be trusted to protect you when the chops were down. This is a lesson that one way or another, many Black people have learned. Many in inner city communities that are actively concerned with safeguarding their neighborhoods, many of them are actively concerned with safeguarding their neighborhoods. Residents in inner city communities are painfully aware that violent crimes committed against poor Blacks, and where there are Black victims again, that they do not get the kind of vigorous response that we see when victims are middle-class whites. If you doubt this at all, what you need to do is to recall the tremendous hue and cry that arises when a middle-class white person is killed in a major city, as opposed to the routine handling of most murders involving inner city or Black residents. Some of this is racism, a replaying of historic indifference to the plight of Black victims, but this also reflects the political priorities of police departments. Middle-class people, particularly middle-class white people, know better how to make the system respond to their needs. They vote in larger percentages. They contribute to political campaigns. They do a better job than inner city residents of organizing neighborhood lobbying efforts. They write op-ed pieces for newspapers. And they might even go to parties with newspaper reporters. They demand and get better responses from police departments, even in cities with Black mayors and Black police chiefs. So in addition to new controls on their behavior and new remedies for police misconduct, police may need a new set of priorities that might lead to better relations with minority communities that simply do not trust them, and for good reason. Now, lest I be accused of not speaking directly to the issue of criminal justice reform, let me note that current protests go to police practices, and demands emerging from protests go to how to change police practices and how to remedy police misconduct. But our concern about criminal justice reform should be broader than that. So I want to speak from outside the box. Let's consider first an institution at the very base of the imposition of criminal liability, an institution recognized and guaranteed by the Constitution. I refer to the jury. The denial of juries to Black people has long been an instrument of racial repression. In the antebellum era, slave jurisdictions had separate criminal justice systems for slaves, and of course, no slave had a jury of his or her peers. And free Blacks could not participate on a jury. Even in many free states, free Blacks were forbidden jury service. This is a model that Southern states would try to emulate in post-Civil War Black codes, and that the 14th Amendment was intended to outlaw. And this is a model used even later. An 1890 case that many law students know, Strouder versus West Virginia, saw the Supreme Court outlaw explicit racial exclusions. But this did not end the practice of racial exclusion and the dominance of all white juries, especially in the South. Our jurisprudence is rife with cases overturned because Black people were, by open subterfuge, excluded from juries and grand juries. Even in today's world, where the Constitution's preclusion of racial exclusion is well recognized, we have to reckon with peremptory challenges in the selection of jurors from the jury veneer. It has been an oft-used and well-known prosecutorial trick to use peremptory challenges to eliminate Black people from the jury, or at least to minimize their numbers. Batson versus Kentucky in 1986 made the use of such peremptory challenges unconstitutional. But the practice is controlled only by requiring that prosecutors offer a race-neutral explanation for their use of a peremptory challenge when there's a questionable situation. One does not need to wonder whether unethical prosecutors take their training in the requirements of Batson to instead be training in how to exclude racial minorities from the jury, but not get called out for it. There are egregious examples, and they are the examples of cases in which prosecutors actually got caught. Miller L. versus Dredke in 2005 is an example where the Supreme Court recognized misconduct when prosecutors were foolish enough to produce an extensive written record of what their thought process was. Flowers versus Mississippi, decided only last year by the Supreme Court, is a case where Curtis Flowers was tried six separate times for murder. At the first two trials, the state used its peremptory strikes on all of the qualified prospective Black jurors. In each case, the jury convicted Flowers and sentenced him to death, but the convictions were later reversed by the Missouri Supreme Court based on prosecutorial misconduct. At the third trial, the state used all of its 15 peremptory strikes against Black prospective jurors, and the jury convicted Flowers and sentenced him again to death. Mississippi Supreme Court reversed again, this time concluding that the state exercised its peremptory strikes on the basis of race in violation of Batson. At the fourth, the state exercised 11 peremptory strikes, all against prospective Black jurors, but there was a mistrial. And while we don't have any racial information on the fifth trial, we do know that at the sixth one, the state exercised 6 peremptory strikes, 5 against Black jurors. In each instance, the trial court concluded that the state had offered race-neutral reasons. The Supreme Court, again on the basis of an extensive record that showed the prosecution's thought process, concluded otherwise. Now, I tell the story of Curtis Flowers not because it's the most recent Batson case to reach the Supreme Court, but it is a story of the persistence of an old practice that is intended to impose white dominance and that has the effect of removing Black jurors whose common experience leaves them suspicious of police.
Professor Diamond?
So, if I may, just a question, not a conclusion. Is this story of Curtis Flowers why we shouldn't have nice things? Should we eliminate peremptory challenges because prosecutors can't be trusted with them? That's just a question. Now, I understand that I will be virtually yanked from the podium if I don't stop, and so I stop.
Thank you so much, Professor Diamond. Our next speaker for the evening is Professor Wendy Green. Professor Green is a professor of law at Drexel University's Thomas R. Klein School of Law. Professor Green is truly a trailblazing legal scholar on the issues of anti-discrimination based on race, color, and gender. Professor Green is the architect of two new legal constructs that have been widely recognized within anti-discrimination theory: misperception discrimination and grooming code discrimination. Her definition of race and the social construct of race have been endorsed in written opinions by the 9th and 11th Circuit Court of Appeals. It's a great honor to have you here with us today, Professor Green.
Okay, well, thank you so much for having me on this really amazing panel this evening commemorating Constitution Day. I am a 2002 graduate, as you mentioned, and it's really quite an honor to be able to follow behind three of my constitutional law professors, though I have to admit I'm a tad bit nervous now about it. But with that being said, hopefully can you all see the presentation?
Yes, we can see it.
Okay, perfect. I just wanted to make sure. Okay, so I will be talking about hashtag Free the Hair, racism, anti-racism, and civil rights lawmaking. What's hair got to do with it? And very much like Professor Diamond, I'll be explaining the ways in which we're currently dealing with what I call the hyperregulation of Black people's bodies. Or another way to think about it is the policing of Black people's bodies, not just simply through our skin color, but through our natural hair texture. Over a decade now, I have produced several legal publications around the ways in which African descendants specifically have encountered what I call grooming codes discrimination, or discrimination on the basis of our natural hair textures and hairstyles like afros, braids, twists, and locks, bantu knots, and so forth. And from this scholarship, essentially what I've attempted to do is to try to increase public awareness around the systematic and global discrimination that African descendants suffer because of our natural hair texture and hairstyles. And in doing so, I have adopted, as one of the audience members mentioned, an anti-subordinationist lens, or today we might consider it to be an anti-racist lens, as it relates to trying to dismantle this form of racial discrimination, this form of racial hierarchy, also known as texturism, a race and color-based hierarchy that privileges straight hair because of its association with Eurocentrism or whiteness, and the denigration of our natural hair textures because they're associated with our African ancestry. And so with that being said, the grooming codes discrimination work that I have done really tries to address a very specific form of inequality, as well as an infringement upon our personhood, resulting from the enactment and enforcement of appearance and grooming mandates or expectations, which really bear no relationship to our qualifications, our competencies, our job performance, our abilities to learn, and should not bear on our ability to access public accommodations, housing, and other spaces. Largely the work, as I mentioned before, revolves around race. And some of the origins in the work that I talk about the origins of this form of race-based discrimination, harkening all the way back to the eras of racial slavery in this country and beyond. And aside from our skin color, African descendants were enslaved, or at least told that we could be enslaved simply on the basis of our hair texture. And this comes from just an example of this from an 1806 case decided by the Supreme Court of Appeals in Virginia, which was modeled after the United States Supreme Court. And in this freedom suit, where we have three indigenous women who are claiming to be free based upon this argument that they descended from an indigenous woman by the name of Butterwood Nan. And in this particular opinion, the court actually does grant their freedom. The court says that they are wrongfully enslaved. And in doing so, they demarcate for us a racial caste system, a system based upon not simply about skin color or known ancestry or parentage, but more specifically about our hair texture. And they tell us, regardless of the kind of multiraciality that may exist, the fact that you may have a fair skin complexion, the one thing that is going to perpetually mark you as African descendant or Black and therefore enslavable is the woolliness of your hair texture. And then they go on to tell us that what is going to mark you as white or European descendant and therefore free is a hair texture that is not woolly nor inclining thereto. And so therefore what the court tells us is that if you don't have a propensity to have woolly hair, they will likely mark you as white or as indigenous and therefore free. But if you have a woolly hair texture, they will mark you as African descendant and therefore enslavable. And so our hair texture has really very much been a central feature in terms of our liberty, in terms of our freedom, our equality, as well as inclusion in this country. Contemporary examples of this, many of you are probably familiar with, is where in 2018 we have referee Alan Maloney, who instructed a high school wrestler, Andrew Johnson, shown here, to cut off his locks or forfeit the wrestling match. And then 2 years later, just this year, we have DeAndre Arnold and his cousin, Caden Bradford, who were effectively suspended from their high school because they refused to cut off their locks. And as you may be aware, Arnold was unable to participate in his graduation because he refused to cut off his locks in conformity with the school grooming code. Now, these African descendant boys are not the only ones who are having their hair shorn in schools. We have here True Robinson, who was 7 years old, where her hair was forcibly cut by one of the school administrators, a weekend school administrator in Massachusetts. They cited hygienic reasons, but they were informed that one of the volunteers told True that by shaving her head, her hair would grow back straight, which tells us something very salient about the persisting belief that straight hair or in its association with whiteness is privileged and elevated, and that you would commit an assault on an African descendant child in order to foster or further that belief. And, this kind of treatment that we're seeing here is a continuum. It happens along a continuum from childhood to adulthood. Just recently, Duke researchers in the Fuqua Business School, they have reaffirmed that Black women with natural hairstyles are less likely to get job interviews than white women with straight hair, white women with curly hair, and Black women with straight hair, and very much signals this preference for a Eurocentric norm as it relates to straightened hair. And to that point, Black women have actually been expressly told that they have to straighten their hair as a condition of employment, to wear wigs and weaves as well as a condition of employment. With that being said, some of the ways in which, not always expressly, are you told that you can't wear your natural hair in workplaces and schools, but oftentimes you see these sort of race-neutral explanations or stereotypes, if you will, that are being associated with our hair as unkempt, disheveled, unprofessional, aberrant, radical, militant, unruly, distracting, wrong, extreme, unusual, unattractive, and unacceptable. And therefore, the conformity or those types of stereotypes and stigmas are so prevalent in our society, our workplaces, our schools, and they are bringing about some very systemic forms of race-based inequality. And for those who think that it may not have anything to do with race, I just provide you with this particular slide as an example where we have meteorologist Coralise Ortiz, who was working. And while working with her hair in its naturally curly state, she was told by one of the observers of the news report that, that they would like for her to wear something a little bit less inward iggery looking. So with that being said, these types of stereotypes and stigmas that African descendants are suffering in our workplaces and among other spaces under current federal court jurisprudence, pretty much this kind of treatment is generally lawful race discrimination. And this is just one headline from a case out of the Fourth Circuit where a judge ruled that a workplace petition that was circulating throughout the workplace calling Black women's natural hair unprofessional is offensive, but it does not constitute unlawful discrimination and unlawful race discrimination, more specifically under our federal civil rights laws. And this really harkens back to what I call a legal fiction in our jurisprudence. Well, basically, what I argue here is a legal fiction are rules created by judicial, legislative, or political bodies, which are not based in fact, yet are treated as such to legitimize zones of protection and inclusion. In effect, these legal fictions narrow the scope of protection against discrimination under our contemporary anti-discrimination laws. And largely the kinds of legal fictions that I have been interrogating are those that I argue are judicially created doctrines that are rooted in biological, fixed notions of racial identity that are developed to deny statutory protection or at least reinforce the deprivation of statutory protection against race discrimination. And one of those types of doctrines that I have been interrogating is known as the immutability doctrine. And the immutability doctrine we see not only in our constitutional jurisprudence, but also in our federal civil rights statutes jurisprudence, or the interpretation of our federal civil rights statutes like Title VII of the 1964 Civil Rights Act. And largely the immutability doctrine came about in race and sex discrimination cases involving the regulation of workers' appearances. And the most recent case is the 11th Circuit case, EEOC versus Catastrophe Management Solutions, where we have Chastity Jones here, who was denied, or at least her job offer was rescinded because she was wearing, as you can see, what is known as curly locks. And during her job interview, or after it was finished, the HR manager told her that she would no longer be able to extend the job offer to her unless she cut off her locks. And she expressly told her that, "I'm not saying that yours are, but they tend to get messy, if you know what I mean." And I say that Ms. Jones says, "No, I don't know what you mean." And she therefore gave back her paperwork and she went to the EEOC and filed a Title VII race discrimination claim against this employer. And in doing so, what the court decided during this litigation is that this discrimination on the basis of her locks was not unlawful race discrimination. And they applied what we know as this immutability doctrine. And in doing so, they basically reaffirmed 40 years of legal precedent that discrimination on the basis of immutable characteristics can constitute unlawful race discrimination. However, discrimination on the basis of mutable cultural characteristics will not fit within our confines of civil rights protection. And so what they tell us essentially from this case is that discrimination on the basis of a Black hair texture is unlawful race discrimination because Black hair texture is an immutable characteristic. However, adverse action on the basis of a Black hairstyle, like locks, is a mutable choice, and therefore it does not violate our civil rights laws. And so what that means in effect is that African descendants, if they're discriminated against on the basis of an afro, then that constitutes unlawful race discrimination. But if you lock, braid, or twist that afro, then magically is no longer about race. It's about culture, and that kind of discrimination does not violate our federal civil rights laws. And so what this ultimately means as it relates to the consequences of this legal fiction like an immutability doctrine is that it maintains racial subordination and segregation, discrimination, harassment, deprivation of employment opportunities, educational opportunities, housing, and so forth in our society. It also perpetuates a racial hierarchy that privileges straight hair, which is associated with whiteness, and denigrates natural curly or coily hair texture that has been long associated with Blackness. And as I mentioned before, it essentially legalizes what I call the hyperregulation or policing of African descended people's bodies through a medium of hair that really very much harkens back to eras of racial slavery and racial apartheid in this country. And for Black women and girls in particular, this civil rights law sanctions a straight hair expectation or mandate that African descended women and girls must satisfy to prevent or at least try to reduce this widespread discrimination and harassment, as well as the consequences in our employment and education context, namely like economic security, psychological consequences, physiological consequences, and so forth. So what I've argued in my scholarship is that we should get rid of this immutability doctrine and that we should think about race as a social construct. And that in doing so, that we should try, when we're enforcing our civil rights statutes, that we should be thinking about race as it is on the ground, which is that it includes physical appearances and behaviors that society historically and presently commonly associates with a particular racial group, even when the physical appearances and behaviors are not uniquely or exclusively performed by or attributed to a particular racial group. And we see this kind of definition of race now embodied in legislation known as the Crown Acts. I see that I'm almost out of time here, I believe. I'm going to be pulled off of the virtual stage. And so just really quickly, I'll just let you know just a little bit about the Crown Act. It's the Creating Respectful and Open Workplaces /World or Natural Hair Act. Thus far, we have 7 states that have adopted this definition that I proposed in that 2008 article. We also have the federal bill that just on Tuesday, the United States House of Representatives Judiciary Committee has advanced, and they will go to the United States House of Representatives, the floor of the United States House of Representatives. And I have to say that fellow Tulane lawyer, Cedric Richmond, introduced that bill, and I was able to have the privilege of co-drafting that bill as well. And then lastly, for those who are lawyers in the field, you probably want to know that the American Bar Association too has endorsed this definition of race that is now being used in the Crown Acts. And so basically what I ultimately want to say here is that these are ways in which we can use anti-racism, we can use anti-subordinationist theories that critical race theorists have often advanced in our civil rights scholarship, and use it in our practice, in our lawyering, and that basically in 2020, it is time to free the hair.
Thank you so much, Professor Green and fellow alumna Wendy Green. Our final speaker for the evening is Professor Kristen Johnson. And Professor Johnson is the McGlinchey Stafford Professor of Law at Tulane Law School, the Associate Dean for Faculty Research, an affiliate of the Murphy Institute for Political Economy, and the Gordon Gamm Faculty Scholar. Professor Johnson is nationally recognized as a leading scholar of financial risk management and corporate law. She has presented her research on systemic risk, risk management, cyber risk regulation, emerging technologies such as artificial intelligence and distributed digital ledger technologies in finance and financial markets regulation throughout the United States and abroad. Just last year, Professor Johnson testified before the U.S. House Committee of Financial Services to encourage uses of alternative data in underwriting and credit score methodologies. Without further ado, Professor Johnson.
Thanks so much. I feel very privileged to join you all, and I am slightly nervous that I may not have the skills to navigate sharing PowerPoint via the screen share, but I'm going to attempt to share. I think, are you able to see the PowerPoint presentation now? I'm hoping that you can. If not, someone's going to send me a text message. It takes me a long time to advance to the second slide. So if you all are unable to see the PowerPoint presentation, please let me know. I will assume that you can see it and proceed from here. So first of all, I just want to thank everyone who's participated on the panel, but especially our wonderful and recently installed Vice Dean Richardson. I also want to thank our Dean and the law school for engaging us as a faculty, encouraging us as a community to be deeply thoughtful about these questions. With more time, I'd spend time thanking Professor Wesley and others, those who've been serving on the anti-racism task force, students and alumni as well. But I have limited time today, and I recognize that I am one of the final speakers after a series of prestigious and esteemed speakers that you have been listening to carefully and cultivating, curating a number of questions that you'd like to raise. So I will join in the fray right where I am in terms of my scholarship and right where I was asked to offer commentary, offer some examples and reflections, and attempt to close out my time, I hope, on time, according to the timeline. So you just heard from Professor Wendy Green describing continuing and emerging concerns, civil rights concerns with respect to grooming and discrimination directed at, in particular, African Americans with respect to their hairstyles. I'd like to press that issue a little bit forward into the future and just begin to talk about not only how historically from the time of the drafting of the Constitution to date, we've seen various types of discrimination emerge, but I'd like to push the ball forward, drawing on Professor Diamond and Professor Green's work, as well as the work of the earlier panelists, to talk about a movement to address concerns in a variety of areas of our society: policing, employment, access to economic resources that may be directly impacted by the integration of sophisticated technology. I'd like to highlight this complex technology quickly and describe some emerging issues that arise as we integrate this technology, in particular in policing by government actors and law enforcement, as well as increasingly by private market actors who are adopting similar technologies to automate decisions regarding employment, education, access to credit that could be in the form of an automobile loan or a short-term payday loan or a home mortgage. I'd like to begin my presentation by thinking about the code. When I'm in class, I'm at the podium and I use the phrase "the code," my students assume that I'm talking about one of several federal securities laws. In fact, in this instance, I'm using the word code in a different context. I don't mean the substance text of the law itself. I mean rather the algorithms that are increasingly influencing how we operate in our society. You're intimately familiar already with what I mean by the code or algorithms, because they are slowly encroaching on every aspect of our daily life. Pre-pandemic, if you flew to an airport to attend an academic conference or to go on vacation, maybe even in a foreign country, you might use your Uber app. You might have used Airbnb to identify a particular apartment or condo that you might have wanted to rent on the beach. You might order dog food or I don't know, workout equipment on Amazon.com, all of which is leading to the creation of a digital footprint that reflects all of your preferences, interests, and tastes. And there are many, many actors in the market who are eagerly anticipating every drop of data that you might offer up. So Netflix will identify for you your favorite film. Google will help you begin to write the text of emails to your friends and family by reading all of your previous emails to discover how you might respond to them, reading all of our previous emails, if that's indicative, right? So you're not unfamiliar. But what are those algorithms actually? In a word or two, I would say the following. Algorithms or code essentially refers to instructions, a set of instructions that might be offered up to a computer program regarding how to analyze or execute instructions on to execute a particular task. My son and I bake banana bread regularly, and that recipe for banana bread is essentially code. It instructs us how to bake the banana bread. The algorithms, similarly, in a parallel fashion, facilitate a process whereby information gathered is carefully curated and carefully studied to create and produce a certain set of instructions about you and how you operate and what you may or may not be interested in. These are simple algorithms, the banana bread recipe or 2 + 2 = 4, an equation, but there are more complex algorithms certainly at play in our society. For example, the facial recognition software on your iPhone or that you use to unlock your iPhone is unique to you because no one else has a face just like your face. Your mom would say that for sure, right? Well, certainly it's the case that this very unique identifier that is associated with you as a person is used as a form of security in the context of your iPhone. The algorithm that reads your face is carefully studying details in your facial features to ensure that anyone else who attempts to use your phone is unable to access the data, information, apps, or programs on your phone. This technology also has a number of concerning uses. In an article published by ProPublica in 2016 titled Machine Bias, the authors revealed a disturbing trend and a terrifying reality. Police and law enforcement agencies are increasingly adopting these fancy algorithmic platforms to make critical decisions in the lives of citizens. License plate reading software, Palantir's use of facial recognition software here in the city of New Orleans to identify potential members of gangs, the use of state driver's license photographs in any number of contexts can be alarming because all of this information might be used. In fact, it is a gold mine for law enforcement agencies. In an article published in the Washington Post and drawing upon research by Georgetown Law's Center for Privacy and Technology, an expose revealed how the FBI and ICE have used state driver's license databases to engage in unprecedented surveillance of citizens. I'm sharing with you in this slide a picture of 2 individuals who were arrested essentially for petty theft. After they were arrested using general policing tactics, no fancy tactics used in identifying them for purposes of their arrest. However, in determining that either of the individuals might be eligible for bail, and increasingly in the context of determining the length of sentences and other very critical questions with regard to law enforcement's detention of individuals or the amount of money individuals might pay to be released from detention while pending trial, or the amount of time individuals might spend in jail. Law enforcement, police, and courts are relying on risk assessment algorithms. Many of you would have seen the ProPublica article. You would be familiar with these 2 individuals. For those who are not, I'll share with you that although both were arrested for petty crimes, their risk assessments, which you can see at the bottom below each picture, signal that one, Vernon Prater, was less likely to engage in crime if he were released on bail, while Brescia Borden was deemed a high risk. You'll note the race of each of the 2 defendants, and we might argue that these algorithms, presumably developed on scientific technology, operate in a manner that enables neutrality in determining how each defendant might be treated by the law. In fact, what we discover is after 2 years, the computer algorithm got it exactly backward. Borden was treated as high risk based on the risk assessment algorithm, but in fact, she committed no crime over the period of time following her arrest, while Vernon Prater was subsequently arrested and serving an 8-year prison term for breaking into a warehouse and stealing several thousands of dollars worth of electronics. So why, in fact, am I suggesting to you that this is concerning, maybe in the context of policing, but in any number of other areas of our society? What are the challenges that relates to the integration of these technologies in society is the limitations of the technologies themselves, as well as the limitations of data sets that are used to inform the algorithm how to think about our society. A wonderful young woman, young scholar, Joy Buluwami, had written, co-authored an article with Timnit Gebru, where they explore the reality that a widely adopted facial recognition data set suffers from what we will quickly call, for limited time, the pale male problem. The pale problem. So what specific the pale male problem? We'll have a quick glance at the pilot part benchmark individual face. What you'll notice quickly over time is that there are more men than women in the data set. So there's an overrepresentation of men and men's faces in these data sets. There's also an overrepresentation of white men in particular. So the paler your skin and the more likely you are male than female, the easier it will be for any algorithm on the data set to. I'll move to my final reflection, which is really a nod to some of the issues occurring in the moments of the pandemic. So with the outbreak of COVID-19 at the beginning of 2020, we would note that a number of government entities, and largely these are state public health authorities, began to introduce a method of identifying COVID-19 positive individuals and those who have been exposed to COVID-19 based on their relationship with COVID-19 positive individuals. And they adopted a long-standing approach widely used by epidemiologists and public health authorities in the past, contact tracing. However, amped up with the assistance of a variety of algorithms, a number of cities, states, and countries around the world began to explore the use of digital contact tracing apps. The digital contact tracing apps were presumably going to enable health authorities to readily identify using GPS or Bluetooth technology who had been in contact with whom. I mentioned the contact tracing apps and the COVID-19 pandemic specifically because in a forthcoming article, I describe how in Carpenter versus the United States, the US Supreme Court recently evaluated whether law enforcement officials had violated a defendant's constitutional rights, that's Fourth Amendment search and seizure rights, by invading the defendant's reasonable expectation of privacy. Specifically, the federal agency had initiated proceedings against the defendant based on information gathered from GPS data associated with the defendant's cell phone, right? And they did this without first seeking a warrant supported by probable cause. They went directly to the cell phone company, asked for the geolocation or GPS data, and used that data to connect the defendant to crimes. The highly anticipated decision is tremendously important and interesting. And in a moment of reckoning nationally in terms of the use of a variety of policing tactics, this kind of adoption of technology is exceptionally concerning, especially when coupled with worries that the data that might be used to train algorithms for policing, the data that might be used to train algorithms for assessing employment candidates' eligibility for hiring, the use of screening interviews, video-based screening interviews, all of which may rely on data sets that are incomplete, that are overrepresentative of certain groups in our society, underrepresentative of others, that contain data about policing that is certainly the result of historic bias in terms of who is policed, how much they are policed, how often they are policed. All of this gives us great pause. And in a moment when we are increasingly tending to rely on technology, particularly not just in the law enforcement context, but also in the private sector space, I would just offer up that Constitution Day of the future would certainly integrate some conversation about the extent to which the rights to privacy as articulated or interpreted by the Supreme Court and our concerns regarding individual liberty should be at the fore of any discussion. I think coupled with racial discrimination concerns and inequities that have well been established by other presenters earlier in the panel, we can see that there is a confluence of concerns emerging here, and we may want to act quickly to minimize the extent to which the liberties of individuals and civil rights of individuals are breached. I will pause there because I believe I have come to the close of my time, and I will stop the screen share effectively, which makes me proud. And I'm happy to engage with my fellow panelists in the Q&A. Thanks so much for allowing me to share.
Thank you so much, Professor Johnson. While Michelle said Professor Johnson was our final speaker, we do have a reprise from our first speaker, Professor Robert Wesley. As you all know, you've already met Professor Wesley, but I did want to offer one more comment about this excellent legal scholar. Professor Wesley is currently the co-chair of Tulane Law School's Anti-Racism Task Force. His leadership on this task force and his years of service to the law school have helped us make progress together towards a more diverse, equitable, and inclusive Tulane. As all of us attending this webinar know, we cannot simply state in today's world that we are against racism. We must endeavor to be actively anti-racist. Professor Wesley's leadership is helping Tulane move in that direction. Professor Wesley, thank you for all of your leadership that you have offered to Tulane, and we look forward to hearing you with your closing remarks before we move to a brief Q&A.
Thank you so much, Sally. I was asked in the beginning to say something about the Constitution and the past. And in this segment of the panel, I've been asked to say something about the future. And I'm going to try to be very brief. It's already been mentioned that a lot of my scholarship has been devoted to the issue of reparations for historical injustice. And most recently, my approach to that topic has been deeply comparative. I've been looking at the fact that West Germany has really fully embraced the need to make reparations to victims of the Holocaust, to determine what lessons that we could learn as Americans from that example and that experience. One of the things that the Germans had to devote themselves to in order to make that happen involved struggling with their past, dealing with their past. They even have a very heavy word for that. They call it Vergangenheitsbewältigung. And in my view, I've been thinking a lot lately about Vergangenheitsbewältigung in the USA, largely as a result of the resurgence of the Black Lives Matter movement. We're living, in my view, at a moment of heightened awareness about systematic and institutional racism, as well as deficiencies in our social and political institutions to withstand unorthodox and unanticipated assaults that devalue democratic and legal norms. So with that as setting the stage, I think that more and more of our institutions will in fact embrace and adopt the slogan of Black Lives Matter. But it's always been my view that if we really believe that Black Lives Matter, we have to also take into account the past. We have to struggle with our past. And that's something that I think many Americans are loath to do. I recently came across a quotation from Professor Thomas Ross when he was writing a critique of the Supreme Court's decision in an affirmative action case where they set the standard of review as strict scrutiny. And one of the things that he said was, and this is a fairly long quotation, he said, "The fear of Black insurrection is part of the unbroken history of the white man's imagination. Our slave laws were especially harsh. Features of those laws can be linked to the understandable fears of white men who often lived in circumstances where the victims of their cruelty and oppression literally outnumbered their masters. To live in a society with people whose great-grandparents we enslaved and who are themselves the subjects of continuing humiliation must give us our own versions of the white slave masters' nightmares," end quote. So I think that there's some truth there, that part of the resistance to looking deeply at the past, working through that past in an honest and open way, in other words, engaging in Vergangenheitsbewältigung, is because certain aspects of American history do not make us look very, very good to ourselves. So I'm going to make a few predictions. I think that there's going to be a lot more embrace and adoption of the slogan of Black Lives Matter, but I don't think that there's going to be widespread defunding of police departments. I don't think that there's going to be prison abolition. I don't think there's going to be a serious national commitment to eliminating the racial wealth gap. I don't think that we're going to get rid of the Electoral College and have popular election of the president. I do think that in the very near future, we probably will totally eliminate affirmative action, whether that's called for by the circumstances or not. I don't think that the 13th Amendment's exceptions clause will be eliminated. You know, there's another, I mentioned Derek Bell when I was talking about history and his concept of the principle of involuntary sacrifice. He also developed this notion of interest convergence, that the Black community is, when it is able to advances when it's in the interest of the white community that should happen. So I think that principle of interest convergence applies to our current situation as much as it applied to things that happened in the past, like Brown versus Board of Education or the 1965 Civil Rights Acts. I think that that we have to be able to think about subordination in ways that that show that it's important for everyone that Black lives should matter. And I think that that's the hard part for us to achieve. I think the easy part is just to use those words. So I'm gonna just stop there because I'm very interested in hearing the Q&A and hearing what the students have to say. I can't hear you, Jade.
Oh, can you hear me now?
Yes.
Wonderful. Thank you so much, Professor Wesley. It's great to hear from you. And now we're going to turn to the Q&A section of the event tonight. So all of our panelists will join us on screen. And the first question, I'm just going to throw it out to anyone to pick up, is, are the current problems of racial injustice in this country solvable through constitutional changes?
Well, I'll start and say no. No, I don't think so. I think it has so much to do with the enforcement of the Constitution, those who are on the courts who are enforcing our Constitution. We have plenty of examples where the Constitution could have been enforced much more expansively and towards guaranteeing the real promise of equality and full citizenship and personhood. So I think that plays a huge role. The courts play a huge role, as well as lawyers and the arguments that are being made before those courts. And then I would argue, even if we're talking about constitutional-based civil rights laws, enforcement agencies too, administrative agencies, and the ways in which they're enforcing it. So you really need, and I'm sure on top of that, you need the executive branch too. So we have a lot of things. You need a lot of things in place, right? I think in order for us to really realize the true promise of the Constitution and our other civil rights laws.
And I also would like to add that I just witnessed in real life that very question be realized when we started to work on Louisiana's non-unanimous jury system. That ultimately ended up in the United States Supreme Court having to step in and declare what had been constitutionally protected since the 1800s to be an unconstitutional use of the Sixth Amendment. So I do believe it is possible for us to engineer this change. But one of the things that came about at that moment in history was an awakening amongst people. So people did not assume that there would be some governmental actor that would fix this problem. This was a movement of the people. And once people got invested in constitutional change, the change followed not only on the state level, but on the federal level. So I can tell you that that is possible, and that is a court that had repeatedly, since 1972, said that the Apodaca decision was going to be protected, and it just got overturned. So it is possible, but it will never happen if we are delegating responsibility to someone else. This is a moment in time where we have to understand what a democracy means. We have to be willing to play our role in that democracy. And if we're talking about changing laws in a state like Louisiana, that's a civil law jurisdiction, that puts a heightened responsibility on citizens, because that is what a civil law jurisdiction is. It depends on people involvement. Last point, I also think we are at a moment in time where we must understand the importance of making this a transitional justice conversation. Transitional justice is what we need to heal these wounds that we have been talking about for this last hour. Transitional justice involves multiple approaches, like prosecuting folks, which I don't think is going to be too useful to us. What is useful is the idea of truth telling. We as a nation have not been truthful about the narrative surrounding race, slavery, and liberty in this country. History books have not been honest, teachers have not been honest, and as a result, we do not really understand this history that is plaguing us. So it is my position that we have two options available, and if we do approach this from a transitional justice standpoint, we are at the very early stages, which is purely truth telling. And that work has to be done. That is important at this moment. And that's one of the reasons why tonight is so valuable. And I really thank Tulane for what it is doing, because this is a truth telling moment.
Can I just hop in and add, I think that was such a powerful description of sort of what we have to do going forward. My reference to Carpenter earlier is in the context of law enforcement. But I attempted to draw in at the very end what's happening with COVID-19. And to Miss Allen Bell's point, I don't think that we have to look back. We can just look around and think about the impact of the lack of organized intervention in Black and Brown communities for workers who were deemed essential and continue to be exposed to the coronavirus and were left essentially without genuine protections. And then later, because of COVID-19, could become the subjects of discrimination in the context of employers' evaluations of who has had or hasn't had, or what types of employment opportunities may or may not be available to them. And so this moment is not just backward looking, it's also present and forward looking is what I would suggest. And I think I would only echo with greater emphasis and enthusiasm what Miss Allen Bell said.
And if I may, what I will do is relate a conversation that I had in the fall of 1978 and relate how I think that relates to the question that was asked. I was in Alexandria, Virginia, speaking to a man who hailed from Norway. We were at a cocktail party and he asked me a question. The question was, why haven't Black people rebelled in this country? That they had been treated so badly, he said, he did not understand why they were not in the street with guns. And by the way, it's not that Black people don't have guns. And my response was, it's because we actually believe in this Constitution. and what it means. We actually believe that the Equal Protection Clause means something. We actually believe in our constitutional rights, and what we are demanding is that those rights be respected. Now, I do not mean to adopt wholly what Barbara Jordan said in the Watergate hearings. She said, "My belief in the Constitution is whole." I think the history that Professor Wesley spoke to, the compromises with racism that are part and parcel of the making of our Constitution, that causes me to say, like Frederick Douglass would have said later in his career, that our Constitution is infected with slavery. What I do believe, however, is what Frederick Douglass said earlier in his career, and that is that our Constitution allows those of us who wish to take action to do so, that the Constitution stands for the principles of the Declaration of Independence. And the question is whether we have the strength, Professor Bell is right, whether we have the strength to do what we need to do.
Unfortunately, our time has drawn to an end for this Constitution Day webinar tonight. But certainly the time for promoting change and moving towards a truly anti-racist society is only beginning. Thank you so much to all of our presenters this evening, to Professor Wesley, Professor Diamond, Professor Green, Professor Griffin, Professor Allen Bell, and Professor Johnson. We sincerely appreciate all of your work on this, all of your legal scholarship, and for spending your evening with us here tonight. Thank you to all of our attendees. We hope you have enjoyed our program for tonight, and we look forward to continuing this conversation in the future.